In my last video, I talked about what everyone needs to do during a trust administration in California. Now I really want to focus in on what to do with real estate during a trust administration. Because when a loved one dies and they own real estate, there's crucial steps that you need to take, from securing the home to filing legal paperwork and deciding how the property should be distributed among the beneficiaries. Missteps can lead to really bad legal issues and unwanted tax consequences. In today's video, we'll discuss many of the components of managing real estate in trust administration. We'll cover securing the property, updating title and documents, understanding distribution options, and important tax considerations like property reassessments and exceptions. I'm also going to share some of the documents that you need to file, so you'll see what they look like. So if there's property held in a trust and the person owning the property dies, first you want to secure the house. The person who died may have given keys to the housekeeper, the gardener, or other important people, maybe the pet sitter, other family members. So you want to change the locks and make sure that the house is secure. You also want to continue to pay for utilities and upkeep and maintenance so that the house stays in about the same shape as it did when the person died. So let's dive right into taxes. There's two major taxes that you need to consider when somebody dies with real estate. The first one is capital gains taxes. So as you may know, when you die, you get a full step up in cost basis at the time of death for anything that you own. That's why you'll need to get an appraisal of the house as of their date of death. And that's regardless of, if they died 2 years ago and you're just getting the process started, which would be unfortunate, but that happens sometimes. You need to get the appraisal as of the date of death, not as of the current moment. So that when the house is sold, you'll have that cost basis, that new cost basis established. And you can report any income taxes that are due upon the sale. So please check out my video on capital gains taxes. We also are concerned about California property taxes. Whenever there's a transfer of ownership, California wants to reassess the property for property tax purposes. So you'll need to file a death of real property owner form, which we colloquially call the DORPO form. And let me actually share it with you. Okay, so here's the form. And basically, you're letting the assessor's office know why the house shouldn't be reassessed, or if it is, what happened upon the death and who's getting it. So you let them know how the house passed. For example, if it went through a trust, you would check that. Did it go to their spouse? Did it go to their kids? You want to check which one that is. What's the address of the house? And then also who's inheriting it, right? And what percentages do they get? Typically, you would list that out. And by the way, this is not something that I recommend you do yourself. You would really want to work with an attorney who's filed many of these, because if you mess it up, you might get a full reassessment. Then on the second page, it talks about whether the house was held in a legal entity and whether there's any leases involved. And then the person who's responsible for the disposition of the house would then sign and certify that everything is correct. And you send this to the assessor's office so that they know that somebody died. You don't just keep it a secret. Okay, so if the property went to the spouse, there shouldn't be a reassessment, right? Because transfers between spouses are exempted from reassessment. If the parent's residence went to the child and then the child moves in and makes it their own residence, then there's a limited exemption from reassessment under Proposition 19. And I have a video on Prop 19 that I encourage you to watch. So I want to share with you the Prop 19 form. So here's the form that we would help you fill out if we're helping you with the trust administration. So you fill out all the information about the property. You fill out who died, that would be the transferor, and who it's going to, and what their relationship is, right? So if it's parent to child, they want to know that it really was a child that the property was going to. Was it their primary residence? Are they filling out a homeowner's exemption form, which I'm going to talk about in a second? Was it held in joint tenancy? So there's a lot of things you fill out, and then you sign and date it to let them know. Okay, so then on the second page, you talk about what did that parent-child relationship look like? Was it a step parent? Were you later adopted? And then the transferee, the person receiving the property, would sign that. If you're filling out and signing and sending in a Prop 19 form, you also have to send in a homeowner's exemption form. So this form is showing that you're moving into that new residence, that you are making it your own. So you do have to fill out your social security number, and if your spouse is living there too, even if they're not an inheritor of the property, you'd fill out their social security number as well. You talk about when you received the property and when you're actually moving in. and it needs to be within 1 year after the parent's date of death. It can't be more than 1 year. You don't get Prop 19 exclusion from reassessment. And then you also say, where were you moving from? If you had a prior residence, if somebody was already living with the parents, you wouldn't fill this in. But if you're moving from somewhere else, they want to make sure that you actually moved out of that one, because you don't get 2 residences, you only get 1. And then you sign and date it. So it's a pretty straightforward form. But again, 1 year, you need to fill it out and submit it within 1 year of the parent's date of death.
Hey everyone, if you like my mom's video, like and subscribe.
So we also need to remove the parent's name on the deed. So typically what we would do is we would fill out an affidavit death of trustee. If the parent was the one who was trustee of the trust before they died, then you'd need to fill this out. And I'm just showing you an example of this. I mean, yours is not going to look exactly like this, but here's just an example. I would talk about the people who established the trust, when did they establish the trust, who were the original trustors and the original trustees, and then when did the first spouse die? So they died, and we do have to attach a certified copy of the death certificate. And then you say, okay, well, so now the surviving spouse is the sole trustee. So this basically removes it. In this case, you had 2 spouses on title. Right? We had John Williams and Susan Williams as trustee of their family trust. We're removing John Williams's name, so it's only Susan Williams as trustee. If you don't remove John Williams's name, then if Susan goes to sell the house, they'll require both signatures. They'll say, well, John Williams is still here, so you have to remove him as trustee. And so this is an affidavit showing that he died, so he shouldn't be listed as trustee anymore. And then it describes where that real property was, and the APN, which is the assessor parcel number, and the legal description. And then they sign it, and it's notarized, and we attach the death certificate. If this is the second death of a couple, or if it's a single person who died, then where should the property be distributed to? Of course, you would look at the terms of the trust. Sometimes the trust just says, this property goes straight to this person, and it's done. But sometimes you have several beneficiaries, or you might have several properties, and it just distributes everything in the trust through percentages. So you might look and say, one child might want one of the properties. And so you say, okay, well, that child gets, say, 50%. There's 2 children in this example. They get 50% of all those assets. Is the value of the house that they want, is it less than or equal to 50% of the total of all the trust assets? And if it is, then they can receive that house as long as there's language in the trust allowing this. We call it non-pro rata distribution. As long as there's language like that, then typically that person can receive the house as part of their 50% distribution. If there's not, then we might need to look into, do they need to have a promissory note or add more money into the trust? It gets a bit more complicated that way. When you determine who's receiving the property, then you file a distribution deed. So this is a deed that goes to the recorder's office, just like the affidavit death of trustee, that says that it goes, like in that example, if Susan Williams then died, then it would be a distribution deed from the new trustee of the Williams Family Trust to whoever's receiving it. And then whoever receives it, we want to make sure that they have a revocable trust themselves, so that when they die, their property won't go through probate. So we want to make sure all family members are taken care of in these situations. So let me cover some common questions that often come up. So one question is, what happens if a family member is living in the house when the deceased person, the owner of the house, dies? What do we do with that family member? Unless they're inheriting the property themselves, they really do have to move out. So how long can you give them to move out? I mean, usually it's several months, because you don't want to just pack them up and put them out on the street. They might need some time to figure out where they're going to move to and pack up all their belongings. They may have lived there for a long time. They might even be a hoarder. And they're actually professionals who can help with sorting through things and getting somebody going. We deal in our office a lot with folks with special needs who might live with the parents. And those people might need some extra support from a professional, especially if the relationship between the kids isn't so good. So you can get as much help as you need to make sure that that person living there is set up in a really good situation. Now, I have an example of what not to do. All right, I was representing this couple with an estate plan, and it turns out that the husband was also named as trustee of his parents' trust. And when the parents died, his niece was living in that house, and he allowed her to live there for another 7 years, rent free. And she was not the one who was receiving the house. And so finally, the beneficiary hired an attorney and sent a demand letter to him saying, hey, we need to sell this house. I want my portion of the house, which is totally reasonable. By the way, I did not represent that guy in the trust administration because he had some cleaning up to do. So please don't do that. Now, what do you do with tangible personal property in the house? Well, first, look at the terms of the trust to see who might inherit it. And, is it some rugs or furniture or jewelry, anything that's not nailed to the ground in a house, we consider tangible personal property. Sometimes people put little stickies underneath the items to indicate, who gets what, or maybe they have a list of different items that they want to go to different people. Otherwise, typically a trustee will do a round robin with the children, and they get to take turns choosing which property they might want. Now, another question that often comes up is, what if several family members inherit a property together and they want to keep the property? They don't want to sell it. Well, I usually recommend developing a co-ownership agreement. And for this, you would usually work with a real estate attorney. So you'd develop what are the terms of that ownership. What happens if one person ends up wanting to sell the property? What do you do then? What do you do with the rent that comes in? What happens if there's arguments that come up, whether over, which tenant should live there, or many issues can come up with, or, maybe one person wants to replace the roof, another person wants to wait another 5 years. So you need to mesh out all of these different items before they come. That's the way to keep the peace in families. So how long does the trust administration process usually take? I'd say usually it's about 4 to 6 months. I mean, we try to move things along as fast as we can, but when you're dealing with the assessor's office, the recorder's office, other entities, and honestly, sometimes our clients, it take a while to get us the information that we need. So I say that that's usually a good estimate of time. So if you've had a California family member pass away recently and they owned property and you need to administer that trust, please reach out to our office and we would be so happy to help. Or if you know someone who would benefit from this video, I ask you to share the video with them so they can learn the process of administering a trust that has real estate in it.
Hello everyone. If you liked my mom's video, don't forget to like and subscribe. See you all next time.